Hassall, LLP.
Mrs. Rogan.
May it please your ladyship. I appear on behalf of the appellant in this appeal with my learned friend Abigail Telford. Mr. Michael Poole's Queen's Counsel appears on behalf of the appellant with Henry Banks-Jones. My lady, this case has remarkably few facts in it. The core facts are set out at paragraphs 8 and 9 of the statements of facts and issue. That's at page 34 of the main bundle. And it's simply this. At 10:50 a.m. on the 24th of June of 2013, the appellant emailed the respondent stating, "Please find attached by means of service upon you a copy of the claim form, the file particulars of claim and the response pack." The email requested acknowledgement of receipt by return. As at the date of receipt, which was, as email always, or it normally is, instantaneous, the respondent had everything necessary for good service, save that the respondent had the documents in electronic rather than printed form. The claimants, the appellant's case, if I can now take you to page 79 of the bundle, is that it's paragraph 107. In such circumstances, it's unclear what purpose is served by a court refusing to validate the service under CPR 6:15(2), unless a freestanding need to enforce compliance with the rules is thought to be sufficient. There's no prejudice. There's no effect on any court timetable. There's no increase in cost. Indeed, email service is probably cheaper than any other form of service. And there is, in fact, as I'll come on to later, more certainty in relation to service by email than there is to service by post. Because good service by post takes place when the claim form is posted to the defendant's last known address, whether the defendant is there or not.
Well, there may be a difference, may there not, between a situation where you're serving the defendant himself and a situation where you're serving his solicitors.
Yes.
The difference is that it is absolutely critical that the solicitor should have authority on behalf of his client to accept service, to accept it by the particular method proposed. You can't simply impose upon a principal the authority of his agent if he hasn't given it.
Yes, of course, that is right, but that's why this service fell foul of the rules. But the question is whether the relatively new 15(2) jurisdiction should be exercised, and whether there's a good reason. So one accepts that conceptually and legally, as far as the law of agency is concerned, that's correct. But this application is not about the law of agency. This application is about a dispensing provision under 615(2). And so what the court has to decide is whether there's a good reason, given that, of course, the contract law is not satisfied, whether it's a good reason to validate service. If service is intended by the claimant in good faith, that the claim form was actually received by the defendant, and that the defendant knew that the claimant intended to serve the claim form or on him or her. And so my primary submission is that in those circumstances, there is little more to say. These solicitors, acting on behalf of another firm of solicitors, knew that service was intended. They had all the documents. The documents were received, but they didn't have a hard copy printout. And it's my primary submission that where those three factors are fulfilled, then prima facie, whether the claimant is in person, whether the claimant is acting with legal representation, prima facie, the dispensing provision ought to be applied. The formalities of service are extraordinarily difficult, even for lawyers. It is difficult to comprehend that any lawyer in the land knows, without looking it up, the full rules relating to service. And not merely the rules, but the nuances that are contained in the cases which have interpreted the rules. Can I take you now to my case at page 59, paragraphs 28 to 30? The Civil Procedure Act quite properly states that when making the Civil Procedure Rule Committee must, when making civil procedure rules, try to make rules which are both simple and clearly expressed. And they came into that, the rules came into force, as we know, on the 26th of April 1999. And one of the great purposes of the Wolf reforms was to simplify, was to improve the language. Many of the terms relating to civil procedure changed. And if one goes back into the Access to Justice interim report, there are explanations which we've set out in relation to this, paragraphs 26 and 27 of my case. But in relation to service, the simplification of the rules has not worked. And without wishing to labour the point too much, in my old edition of the White Book for 1999, there were 55 pages devoted to rules, well, orders, as they were, order 5 to order 10. Another 22 pages devoted to order 65, which dealt with service, amongst other things. It is obvious to all of us that the White Book is bigger than it used to be. Bigger, each page is bigger if one holds one over the other. If you look at all the rules now about starting a claim, and serving a claim, including, I accept, rules relating to service out. The White Book is now 251 larger size pages. And we not only have rules, but we have practice directions. And to anybody who would say to my client, you should have looked at the rules, that wouldn't necessarily be correct, because somebody would have to say, you must look at the rules and the practice directions. And these are not easy to find, as we have tried to demonstrate in our case. Now, it's easy to say that lawyers in general, solicitors, counsel, judges, do not always understand the rules relating to service. But in fact, I can prove it by reference to this case. So, for instance, if one goes into the authorities bundle, to tab 28, page 1074, we're in a glossary of the definitive handbook for litigants in person. The front page is on page 162 of the bundle. And we can see that the editor-in-chief was a distinguished circuit judge, as indeed are all of the other the other 5 circuit judges.
You mean 162 or?
1062.
Oh, I'm sorry, 1062, yes. Now, this handbook was the product, as I understand it, of at least a year, if not longer, of discussions. And of course, service is not the only issue dealt with. We've reproduced in the authorities bundle the chapter 7, starting and responding to proceedings. But it's the glossary that I would commend to the court, because there's a definition of service in the glossary at page 1074. And that definition starts off well enough. The process by which documents in court proceedings are brought to the attention of a litigant. There are detailed rules as to service contained in CPR Part 6. A few documents will require personal service. Most documents will be served by post. Where a solicitor's notepaper includes a fax number or email address, documents may be served by fax or email, unless the solicitor's notepaper states that service by these means is not accepted. Well, that's the same mistake as made by my litigant in person. There are other errors that have within this case.
But I mean, you're not suggesting that your client consulted this.
No,
I mean, if he had come and said, yes, I made this mistake because I read this very handbook and look where it got me, that might have been a good reason. But in your case, I mean, his reason was rather simpler than that. It was just that they had communicated with him by email up to that point.
Yes.
And there'd been no suggestion they wouldn't accept service by email.
I couldn't possibly suggest that he'd read the handbook because it was published after he'd tried to serve. But
I mean, if one's trying to identify what is a good reason for which we should dispense with service. And as I understand it from his statement, it is that, one, the objective was achieved, two, he made a bona fide mistake because he assumed that having communicated with him by email and not said they weren't prepared to go on
Yes.
and communicate by email, that would be good enough. And that's his case, isn't it?
It is.
Yeah.
It is.
Question is whether that's good enough.
The question is whether it's good enough, and I perceive that this court will give some guidance in relation to that might well be used in relation to other cases. And so I'm starting with the general, and I'm going to move on to the particular. But with respect, I think unless one starts with the general, unless one goes into the factual matrix, not a current popular term, but never mind. Unless one goes into the factual matrix of what is behind this dispensing provision and why this dispensing provision ought to be exercised liberally, then the particular case does not sit as well. And so I'm starting with with some general points, because I'm going to come on later to why the guidance in Hassall and Natalie should have no significance in a service case. But unless I get my groundwork done, I'm going to find it more difficult. So that's proof positive that it's difficult generally for lawyers and judges to get service right. In the judgment of District Judge Wall, which I must say I don't intend to refer very much to, but in the judgment of District Judge Wall, at paragraph 23, he says that service was attempted on the very last day permissible. Well, it wasn't. He thought it was. He said it in good faith. It's an eloquent judgment of a judge who thought long and hard about the case. But in fact, if one looks at CPR 7.5, a rule which bafflingly is therefore in 7 rather than 6. It's possible to see that service was in fact attempted on the day before the very last day permissible. The CPR 7.5 is at page 533 in the authority. It is bundled volume number 1.
Mr. Elgott, you said that you don't intend to refer much to the district judge's judgment. I did have a query about that. Would you mind my putting it to you at this stage?
Of course.
If you've got 180 to hand. It relates to a possible issue as to your client's particular experience of litigation and knowledge of the rules.
Yes.
And the sentence that caught my eye is 5 lines down from the top of 180, where the district judge, no doubt having the file in front of him, said that the claim form had a covering letter, must be a covering letter to the court, in which the claimant specifically referred to limitation, and he acknowledged the need to finalize his particulars of claim, and that he needed to serve both the claim form and the particulars. Now, I couldn't find the covering letter to the court in the bundle. Is it there?
Well, I'm bound to say that I've never seen it.
Has nobody asked the county court for a copy of that? Well, anyway, we'll have to make do with the district judge's summary of it.
Yes.
But you will, in due course, in your own time, deal with the possible inference from that sentence that your client is a shrewd and relatively knowledgeable litigant in person.
I've got to deal with this, and I will do.
Very well.
Except I won't be dealing with that particular part. CPR 7.5, page 533. Oops. There's a chart. I mean, interestingly enough, part 7, if one goes back a page, is headed "How to Start Proceedings," the claim form. And yet 7.5 deals with service. This is not easy, I perceive, for lawyers, and certainly not easy for a litigant in person. So we can see that where the claim form is served within the jurisdiction, the claimant must complete the step required by the following table in relation to the particular method of service chosen before 12 midnight on the calendar day 4 months after the date of issue of the claim form. And that is the day after he tried to serve by email. So it's just a small mistake. Of course, my client would say, well, I just made a small mistake as well. Can I take you now, so that's 2. Can I take you now to 3, which is in the respondent's case? Can I take you to paragraph 52 at page 125? Paragraph 52 of the respondent's case says, the implied criticism of the respondent's solicitors, which has permeated the original application and successive appeals in this matter, is completely without foundation, not merely without foundation. There was no realistic opportunity to warn the appellant that service had not been effected by email in time for the appellant to reserve by the correct means, given the very late stage at which the appellant had attempted to effect service. The time for postal service had already passed. It hadn't. It's Rule 7.5 again.
But it was still very late.
Well,
You're not saying they had some sort of duty to sort of...
with respect, no, one understands that point. The only point I'm making at the moment is that it's very easy for people to make mistakes in relation to service. And so we not only have judges in the last 2 examples, but we even have the respondent's counsel in the case before your lordships, which contains an error of the same magnitude as the error that the claimant made in this case.
Is it relevant that your client left it to the last moment before the expiry of the limitation period? I mean, of course, you have the entirety of the limitation period in which to effect service. On the other hand, the closer you come up against the end, the greater the risk that you assume that if something goes wrong, you will not have time to sort it out.
Yes. Well, I mean, clearly, I've been asked this question from different sources. Let me grapple with that now, somewhat out of order, I think. My client is a litigant in person. He has to do a particulars of claim for the first time in something of the highest of complexity. He's an ordinary man with an ordinary job. He's not a lawyer. He's not being paid to do this. He sees that he has 4 months in which to do his particulars of claim. His particulars of claim are extraordinarily long by the standards of lawyers, but he's a litigant in person. And it takes him 4 months to be able to get it right. And so, although one accepts that had he not been a litigant in person, it would have been easier for somebody whose job it was to get it sorted out within the period of time allotted.
But he knew that he did have to. He knew what the allotted time was, and he knew he had to comply with that.
And he did. The one thing he got wrong was that he didn't send hard copies. So he got everything else right, notwithstanding that even lawyers make mistakes in relation to service, and even judges make mistakes in relation to service. He got everything right, but he just didn't send hard copies. The respondent's case also says that CPR 615. Oh, I'm sorry. This is paragraph 78.4. This is a conclusion. The paragraph 78.4, page 135. Says CPR 615 does not exist to protect special classes of litigants, whether in person or otherwise. 615 exists to protect those who, for some reasons beyond their control, have been unable to effect service within the rules. With the greatest of respect to my learned friend, CPR 615 does exist to protect people who have made mistakes. And there is a rule which complies with the description given to 615, and that rule is 7.6. That's at page 534 in the first volume of the Authorities Bundle. And 7.6 deals with extension of time for serving a claim form. 7.6.1, the claimant may apply for an order extending the period for compliance with Rule 7.5. The general rule is that an application to extend the time for compliance must be made within the period specified by 7.5, or where an order has been made under this rule within the period for service specified by that order. And then 3, if the claimant applies for an order to extend the time for compliance after the end of the period specified by Rule 7.5, or by an order made under this rule, the court may make an order only if A, the court has failed to serve the claim form, or the claimant's taken all reasonable steps to comply with Rule 7.5, but has been unable to do so. So that's my learned friend's description of 6.15. And in either case, the claimant has acted promptly in making the application. So 6.15 has got to add something to 7.6. And so we would argue on this side that it's inherent that it is there to deal with mistakes. It may deal with other issues as well, because good reason is not only limited to a jurisdiction over mistakes. And indeed, in a bailer, which I'll come back to later, when Lord Clark set out in his speech reference to the purpose of 615.2, he cited from the White Book then extant, saying it was intended to remedy the mischief perceived in Elms and Highgrove. And Elms and Highgrove itself, which I will come on to later, was a case where the claimant had made a mistake. My recollection is that the claimant had served on the insurer rather than the solicitor, or something of that nature. I mean, finally, if I can take your lordships to paragraph 5 on page 110 of the respondent's case. It's said in the middle section of paragraph 5, the appellant's application notice filed at Chesterfield County Court made no reference at all to CPR 615. Well, this appears to have been a misunderstanding by those acting on behalf of the respondents. Because if one goes to page 292 of the main bundle, what one sees in box 3, what order are you asking the court to make and why? We see it's to amend the claim form and to deem that service of the claim form and particulars of claim via email on the 24th of June 2013 was good service. So people make mistakes about service all the time in practice. If I move now into the factual inaccuracies that there are in the respondent's case, I move into the particular. Now, the evidence of what the claimant knew and didn't know about the rules relating to service is in his own homemade witness statement at page 294. So that's the very next page of the bundle. So paragraph 1, the claimant believed in good faith that he'd correctly served. Paragraph 5, he says, as my Lord Carnwath points out, the defendant's solicitors actually did inform the claimant they were authorised to accept service, as they stated in an email. 6, the claimant believed, because the defendant's solicitors had initiated contact by email and all correspondence thereafter exclusively by email, the defendant was expecting service by email as this had been their preferred method of communication. The claimant was aware that some solicitors don't accept service of documents by email, as reference is made in their legal notices. And he gave an example, which I don't think has been copied in, but there's an example from Ronaldson Solicitors, which was taken from the web. In contrast, the defendant's legal notices, as contained on their website, again, there's an exhibit, makes no reference to not allowing service by email. And so the claimant, a litigant in person, unaware of CPR Rule 6.3 stating he needed permission to serve by email, actually it's the practice direction, but never mind, clearly believed he was in order to serve in this way. He did so at 10:40 on the 24th of June. He served a day earlier than the deadline to allow for personal service if for some reason the email did not get through. So here he actually gets it right where the district judge gets it wrong, except he didn't realise he could serve by post as well. And the claimant's email system shows the email was immediately safely delivered to the defendant's solicitors. This was further confirmed by the immediate receipt of an automated message from the defendant's Jason Nash. Claimant was mindful of the need to minimise legal costs and believed that, given that the email presenting his claim had been safely received, it wasn't necessary also to personally serve. I mean, that's the evidence about what the appellant knows about service. There isn't any other. However, the respondent's case is full of references to the appellant being a seasoned litigant. I take that quote from page 116, who has conducted litigation himself entirely successfully and without legal assistance. But in fact, as is well known to the respondent, the appellant has brought one claim in his life, apart from this, and that was the claim in which Wright Hassall acted for him. So the two claims he's brought are, number one, the claim where Wright Hassall acted for him, and number two, the claim he's tried to bring against Wright Hassall. And Wright Hassall were on the record for him in relation to the claim about which he wishes to sue from the 12th of April of 2005 to the 17th of May 2007. They came off the record at that date, and there's an issue as to about that within the particulars. They came off the record on that date, and unrepresented, the claimant went to a mediation himself 7 weeks later. So that seems to be the description of that appears in the respondent's case. He's conducted litigation himself entirely successfully and without legal assistance. He went to a mediation and the claim was successfully settled at the mediation. So there is absolutely no evidence that this man had ever served proceedings before. Can I pass on to the other misrepresentation? Paragraph 39 states, this is at page 121, he admits to being aware that many solicitors do not accept service by email. He doesn't. Indeed, the statements of facts and issues agreed by both parties states at page 33, some solicitors, because that's what is said in the evidence. He was aware that some solicitors do not accept service by email. Not that many solicitors do not.
Mr. Elgott, I mean, these are niggles. They've niggled your client, but they're not central, are they? I mean, we can read his statement. You've already taken us to it. We know exactly what he said. How wise are you to spend time on niggles?
Well, one man's niggle is another man's
Very well.
big point. No. If it's not helping, I won't go on. The point is that as one goes through the case, the hyperbole is ratcheted up.
Yeah, but I mean, we have to approach it on the basis of the fact that what he said in his witness statement, which hasn't been challenged.
Indeed.
So, we're not, whatever hyperbole the other side may have used, we will be able to put out of our mind, I suspect.
Indeed. All right. But all right.
Well, to be fair, it was put to you that your client was a seasoned litigant. It was put to you by my lord, so perhaps that's why you were dealing with the niggles.
Well, I didn't really wish to say, but I'm grateful for the
But we need to get on to the substance of the matter, the principle. Yeah.
Of course we do. So it's difficult to resist the bit that says the appellant was at all times aware of the import of the rule with which he failed to comply. I mean, he wasn't. Anyway, there we are. Right. The next point is that these hard edges to the rules relating to service are not intuitive. They're certainly not. They might be intuitive to people who've been to law school, but it's difficult to believe that they are intuitive to lay people, and so when we've been preparing this case, as is quite difficult. Sometimes we have to try and think our way into the mindset of a litigant in person. So lawyers know that the rules relating to service can have the hardest of edges, that the smallest of errors can lead to the case being struck out. But why a litigant in person might think that isn't clear. We've seen in my case, which I won't take you through, that the definitions of service are all about getting the document to the other side. The definitions are not about getting the documents to the other side in strict legal form. Forgive me, with strict legal procedure. And so this is perhaps a relic of the days when a writ was a summons from the Crown, as my Lord Sumption referred to in an entirely different context, it's true, in a bailer. And that might be the reason why the rules relating to service develop such hard edges. But it's difficult to believe that this is intuitive when we all know from a bailer what the purpose of service is. And if I can take you to my case, page 51. What we have here, the purpose of service, the judicial definitions. The purpose of service, quite obviously, is to bring proceedings to the notice of a defendant. It's not about playing technical games. That's a well-known citation in this litigation. Can I venture to submit that the reference to technical games is directed at the service, not the antics of a defendant trying to evade service? In other words, service is about getting the claim form to the defendant in some way or another. There's nothing technical about evading service. There's nothing technical about a defendant saying, I'm not going to give you my address. That's not technical. What is technical is using the rules to fulfill a purpose that the rules should not be fulfilling. And so I'd ask the court to consider the reference to the playing of technical games in that context.
Are you submitting that any reliance on the practice direction constitutes the playing of games if the defendant knows the contents of the impermissibly served document?
No, there obviously needs to be more. But if you have a situation, the way I started my submissions, where the claimant intends to serve, the defendant knows the claimant intends to serve, that what the claimant is being done in good faith, albeit mistakenly, and where the defendant has everything they need within the time permitted, then I do argue that the taking of the point is the playing of technical games.
What if there's no authority to accept service by that method?
Even if there's no authority to accept service by that method.
I mean, how can an agent, such as a solicitor, possibly accept service without authority?
Well, he doesn't accept service without authority, with respect, unless and until a court validates the service, and thereby on a contractual construction, the court then makes up the gap in the contract between principal and agent, and so unless and until the defect is waived by the defendant, or the court says that we will deem service made improperly to be good service, then there is not good service. And so it's not a good position for a claimant to be in. But it is a position enabled by the amendment to the rules in 2008. And so, again, going back to Elms and Highgrove, the insurer had no authority to accept service. Service was made on the insurer. It should have been made on the solicitor. And in a bailer, it is said that it was to enable that sort of situation to be remedied. So, I mean, can I take this further? It's very difficult to know the game played by a defendant in trying to avoid service might be termed to be technical. It's just straightforward, evading service, not letting people know where you are. So with respect, my submission is, and I appreciate I have two members of the court from a bailiff, but my submission is that the technical games mean not quite what has been suggested in this case in the past. So, can I come on to the purpose of the email rule? We have a rule. It's actually the practice direction, which seems to give primacy for service by first-class post. And service is effected by placing the document in a postbox. That's it. The rule's on page 503. There's no record of posting required. I mean, on the other hand, email has its own electronic trail. So that's practice direction 6A 3.1. So that's all you need to do. But good postal service, CPR 6.96, at page 468, good postal service can be achieved at an address that the claimant knows the defendant is not at. Yeah, 468 to 9 are the references. Now, we all know that emails have trails. We know from the Law Society guidance that goes back as far as May 2000, and the guidance is at 1056, that there ought to be email policies for all solicitors. And this, of course, was a very large firm of solicitors. It wasn't a sole practitioner. And one would have imagined 13 or 14 years on from the Law Society's guidance that they were having their email boxes monitored, as the Law Society had suggested. This guidance was later reinforced, and I would argue that the rule itself has little or no value in these circumstances, particularly if the rules relating to email service are contrasted to the rules relating to postal service, where judgment can be entered against defendants who have no idea that they have been properly postally served because service was at the last known address. So, it does seem odd that somebody could do this. Could serve by post, enter judgment with all the defects that may be. Of course, there'd be the applications to set aside and whatever. But at the same time, sending an email with all the right documents to a large firm of solicitors, a fortiori, a large firm of solicitors acting on behalf of another large firm of solicitors, who ends up being struck out. And I would argue that the purpose, that were there to be no way back for a claimant in the position of my client, then Article 6 of the Convention would be engaged. And because if there's little or no value in the rule, in the circumstances of a particular case, but more importantly, generally, then Article 6 may be engaged, because my client has been deprived of the right of any trial. And the case I'd like you to look at, the single case I'd like you to look at, is the case of Meeson and Belgium. Not referred to specifically in the case, but it is in the authorities. It's quite a recent case. And it's only promulgated in French. And so forgive us for not having it in the original case. Can I take you to the English translation we've got at page 995? It's tab 20. Forgive me. Just let me go back. Page 913, which is the Human Rights Court's own guide, which is 913. So there has to be a right that's practical and effective. That's on the left-hand side page. Paragraph 70. In the specific circumstances of the case, the practical and effective nature of the right of access to a court may be impaired. For instance, if we then go over the page to the top of 915, by the existence of procedural bars preventing or limiting the possibilities of applying to a court, then the first bullet point, a particularly strict interpretation of the domestic courts of a procedural rule, excessive formalism, may deprive applicants of their right of access to a court. And the final case, the most recent one, is Meeson and Belgium. And that's what I would ask this court to look at. And so if we then go on to tab 20, this was the equivalent, I suppose, of an application under the criminal compensation legislation then in force in Belgium. And what had happened was that the legally represented claimant had failed to combine his application and his response to the state's objections into a single procedural document. And so the appeal to the Council of State was therefore struck out. And that's paragraph 22 of the judgment, which goes from 998 to 999. It's a fairly short paragraph, paragraph 22. Now, the judgment on the merits runs from paragraphs 58 to paragraph 74. And there the parties' contentions are given. The raison d'etre of the rule can be found at the bottom of paragraph 60. This allowed to lighten the work of the Council of State, which must, regarding an administrative appeal in cassation, decide within 6 months of the adoption of the order in inadmissibility without neglecting the rest of the ongoing litigation. So it had a purpose, as indeed the email rule has a purpose. But that purpose was held not to be sufficient. And so if I take you to the court's assessment now at page 1010, paragraph 63, we have the standard human rights law halfway down the page, towards the bottom of 63. A limitation will not be compatible with Article 6 if it does not pursue a legitimate aim, and there's no reasonable relationship of proportionality between the means employed and the aim sought to be achieved. There's reference over the page, paragraph 65. The court recalls that regulations relating to formalities applicable to bring an appeal are intended to ensure the proper administration of justice, and in particular, respect for the principle of legal certainty. 66. However, the court has repeatedly held that the application by domestic courts of formalities required to be complied with in order to bring an appeal can potentially infringe the right of access to a court. This is the case where the overly formalistic interpretation of the ordinary law made by a court precludes the substantive examination of the applicant's appeal. Well, the argument in this case is that, of course, English law allows for a discretion, or in this case, the discretion is not the right word, but has a deeming provision to prevent the striking out of a case being a breach of Article 6. And the question that the court has to answer is that whether failing to provide hard copy documents and just providing them electronically is the kind of error, is the kind of issue which engages Article 6. Because the purpose served is not readily understandable, save, as my Lord Sumption would no doubt say, that there is a hiatus in the contractual issues, which are of course unknown a fortiori to a litigant in person. So, I mean, clearly, to do justice to the case, the whole of the case needs to be read. I do, however, commend the concluding paragraphs to the court. Paragraph 70, the obvious paragraph about the court's task is not to substitute itself to the domestic courts.
Well, basically what the court held was that it was a legitimate aim, speeding up and simplification of appeals, but it was disproportionate to refuse to consider the substance of the appeal merely because the document didn't do exactly what the court said it should do.
Indeed, and that's the parallel that I seek to draw here. There is a dispensing provision. The dispensing provision ought to be considered on the grounds of Article 6, as well as on the grounds of current English case law.
I'm quite sure whether you're saying that the restriction in the practice direction, which permits service by email only where the recipient or their solicitors have said they'll accept it by email, is itself contrary to Article 6, or whether you're simply saying that the exercise of the discretion not to grant retrospective validation is contrary to Article 6, or both.
Well, I'm only concerned in the decision in this case. I don't seek to say that the rule is not compliant, because there is a deeming provision that I can rely on, and so I don't need to go that far. And frankly, we haven't considered it. But where there is a deeming provision, then the deeming provision, we would urge upon the court, ought to be exercised by balancing the utility of the rule with the draconian nature of the sanction, which is the loss of the case.
I mean, I think it's very hard for you to say that the courts below have been guilty of a particularly strict interpretation of the part of the practice direction which requires and permits service by email. No. And so in answer to my Lord Briggs, I expected you to say that you were really complaining of a particularly strict interpretation of the retrospective validation provision.
Your Lordship puts it much better than I have. Yes, can I now go back to a bailer at page 657? It's tab 4 of the authorities. It's obviously, I'm obviously in a slightly difficult position trying to make submissions as to what was meant in a bailer when I've got two members of the court in a bailer who probably know rather better.
It's a problem that people suffer all the time.
Well,
they simply mustn't let it put them off.
Well, I'm trying not to be put off as much as I can. Yes, so
so where do we find a bailer?
A bailer is tab 4. It's the first authority in the bundle because it begins with AB.
And this bundle 2.
Yeah, it's authorities.
657. Memory.
It is.
Memory 657.
Thank you.
It is. Well, the important passages, which I take it that the court is already familiar with, are from 33 to 38, paragraphs 33 to 38. Yeah, this is on page 671. The question is whether the judge was entitled to hold that there was a good reason to order that the delivery of the documents to Mr. Azuri on the 22nd of October 2009 was to be treated as good service. Whether there was good reason is essentially a matter of fact. And with respect to the decision in the court below in this case, we do seem to be getting away from this simple maxim.
Well, he says earlier on in paragraph 23 that it's not exercising discretion but reaching a value judgment based on the evaluation of a number of different factors.
Yes.
You would accept that description?
Yes, indeed. So,
He goes on to say the greater the number of factors to be taken into account, the more reluctant an appellate court should be to interfere with the decision of the judge.
it is. And so I perceive I have to go into the decision of the Court of Appeal to show how, in my submission, the Court of Appeal has not actually done what it should have done as per Abela. So, 35 repeats the point. The court should simply ask itself whether in all the circumstances of the particular case there's a good reason to make the order sought. It should not be necessary for the court to spend undue time analysing decisions of judges in previous cases which depended on their own facts. 36. The mere fact the defendant learned of the existence and content of the claim form cannot without more constitute a good reason to make an order under 615(2). If the claimant had said, as in several of the subsequent cases, said, here is the claim form, but not by way of service, that's obviously not sufficient. So it cannot without more constitute a good reason. But on the other hand, the wording of the rule shows that it's a critical factor. Now, critical is the key word, I would argue, to Lord Carnwath and Lord Sumption, who were in Abela. But the critical word, the word, forgive me, the word critical is the most important word. Critical can be used to mean decisive. It's a strong word. It's obviously the sine qua non, if we can still use Latin. And then there's the reference to remedying what were thought to be defects as matters stood before the 1st of October 2008. Reference to Elms and High Grade, as I've already referred. And the editors of Civil Procedure, the particular significance is that it may enable a claimant to escape the serious consequences that would normally ensue where there's been misservice, and not only has the period for service of the claim form fixed run, but also the relevant limitation period has expired. To put it bluntly, those cases that are misserved close to the end of the period of validity of the claim form, because they are the standard cases. The cases that are served badly, wrongly, and there's no time for reservice, are the cases where it's necessary to involve 615(2), otherwise you could just reserve. So all of these cases, you would expect to be cases where there's been service right at the end, towards the end of the validity of the claim form. And then there's 37. Service has a number of purposes. The most important is to ensure the contents of the document served. Here, the claim form is communicated to the defendant. There's the reference to what the judge had said in Olafsson and Gisrat. And the whole emphasis of a bail is on the claimant having tried to serve and the defendant having got to know about the service. And the rest of it is a gloss, an important gloss, but nevertheless, the critical part, the core part, is that service, in the way that a layman would understand it, is the key to the understanding of the dispensing provision. And it's not just service in the way that the layman would understand it. It's service in the way that the draftsman of the glossary to the CPR understands it. Because as I point out in the case, the glossary does not refer, the glossary definition of service does not refer to these hard edges. Now, of course, I can't say that my client read the glossary to the CPR. If he'd have read the rule, if he'd have read Rule 6, he'd have seen that there are definitions in Rule 6.2, that don't include a definition of service, which is somewhat odd, and don't refer anybody looking at the rule to the glossary. So how somebody is expected to find it, particularly a layperson, one doesn't know. But for what it's worth, the glossary definition of service, which I think it comes at the end. Oh no, it doesn't. Forgive me. My learned friend will tell me where it is. But
is it 653, possibly, yeah. Mr. Elgod? 653, possibly?
653, I dare say. Yes, 653 it is. It's the other volume, indeed. Yes. The service is steps required by rules of court to bring documents used in court proceedings to a person's attention. So not prescribed steps, for instance, which, with all due respect to the draftsman, would be a better definition. But anybody who is not a lawyer reading the only definition of service in the rules would see it's the steps required by rules of court to bring documents used in court proceedings to a person's attention. And the emphasis is not on the rules. That's not the emphasis. The emphasis is on the purpose. The emphasis is on bringing the documents used in court proceedings to a person's attention. So, paragraph 38 of a bailer, going back to 672, refers to the respondent being fully aware of the contents of the claim form because it's gone to his lawyer. The quotation about the purpose of service is bringing proceedings to the notice of a defendant. It's not about playing technical games. I've dealt with that. Paragraph 40 I rely on. it was submitted the judge did not have regard either to the 3.5-month delay between the time the appellants issued the claim and the time they instructed counsel to settle particulars of claim, or to the fact that the claim was time-barred. And so in Abela, there was, I think, with respect, proper criticism that could be levelled at the claimant, that they know they've got 6 months to serve. They know they're serving somebody who may well cause difficulties. They wait 3.5 months to even instruct counsel. We don't know when counsel comes back with his settled particulars. And it's difficult to categorise, in my respectful submission, this 3.5-month delay as being something that can be waved away in Abela and Badarani. But the fact that my client has actually got it there within time, but electronically and not in hard copy, a litigant in person would say that the standards that apply to city solicitors are not the standards that apply to litigant in person. And indeed, in the other cases, Power, in which I was in, as well as my Lord Briggs, in Power, there were some blunders made by the firm of solicitors who acted for the claimant. In Power, the claimant didn't even intend to serve. In Power, the solicitors who were acting sent the claim form to be issued for solicitor service, but by accident and without notifying the solicitors, they actually served on the claimant. Served on the defendant. Claimant solicitors never knew that. They let the 4 months elapse because they didn't have a proper system for checking whether claim forms had come back from Salford. And nevertheless, in that case, where forgive me, and service was on the wrong person, service was on the client rather than the solicitors, who it should have been on, because they'd been notified in writing to serve the solicitors. And so there were some blunders. It was true that in Briggs it was said that the defendants were playing technical games as well. But again, if one compares and contrasts the culpability of the claimant's solicitors who I acted for in Power with the culpability of Mr. Barton, then one would have thought in ordinary circumstances that the solicitors who were doing that kind of thing professionally would be more culpable, and particularly in a case where they had never intended to serve the claim form at all. It just got served, albeit on the wrong person by accident. In the case of Khaki, another decision of the Court of Appeal, again there was criticism, seemingly valid criticism, of the city solicitors who were acting in that case for failing to do all they could to get the case served within the relevant time. They missed the time limit by a few days in Khaki. And the defendants' counsel argued vehemently that they shouldn't be given credit for their own defaults in not moving more quickly. But it seems, although it seems to have been accepted, that there were more than Mr. Karki's city solicitors could have done to get the case served. Again, the deeming provision was exercised in favour of the claimant. Well, in our case, the error made by a litigant person is much more understandable. So in all of those cases, a Baylor, Karki, Power, mistakes have been made. But those mistakes didn't lose the claimant the benefit of 615(2). And so this delay of 3.5 months is waved away by Lord Clark down at letter C. As to the 3.5 months delay, the judge must have been aware of it. It seems to me to be likely he took the view that given the difficulties which faced the appellants in serving the claim form, the delay made no difference. He was entitled to do so. The critical points were that the documents were delivered within the 6-month validity of the claim form and brought to the respondent's attention, and that service via diplomatic channels had proved impracticable. Well, I mean, it might be said I've got the first, but I haven't got the second. Can I now take you to 48? Now, 48 is a paragraph which, in my respectful submission, has been elevated to the matter of critical importance in a way that it should not have been.
What are we doing? 48 of?
Of a Baylor.
Yes, I wonder how much of this is helpful. I mean, Baylor, we've dealt with the part about, well, the judge dealt with it, which we ultimately held was not disclosed error of law. But the critical part, 42 onwards, was a completely different point, which was that the Court of Appeal had gone wrong and in particular taken a particular view of the jurisdiction to serve out,
yes,
which we said was not justified. So, frankly, all is a long way off from the facts of this particular case.
Well,
I wonder how helpful it is to spend time on it.
Well, my lord, up to a point, because the point relating to the focus on the time period between issue and service of the claim form appears in a Baylor in a particular context. And it's my submission that when a Baylor is read in context, then the fact that this has been issued late, forgive me, that this has been served late, does not have the weight that it has been given. Because what
and all that was being said there was that provided it's served in time, then one has to treat it on that basis. The mere fact that they've waited the end of the limitation period is neither here nor there.
Yes.
But that's not this case.
Well, in this case, there has been criticism of my client for waiting until almost the end of the expiry of the period of validity in order to serve.
Well, that's only going to the question of whether what the other side should have done about it. But I mean, I don't think that's a major point.
Well, I'm obliged. The Court of Appeal took it as a major point, however. In fact, I mean, look. With respect, the context of this is that the Court of Appeal had looked at all the delays, including the delays prior to issue of the claim form. And Lord Clark said, in 48, Lord Clark is saying, no. In these cases relating to claim form, you only look to delays if necessary or whatever, but you only look to what happened after issue. And so the context of 48 is the Court of Appeal in a bailer were looking at all the things that could be said against the claimant for the whole period of time. But Lord Clark said, no, you can only look at what happened after the claim form was issued in these cases. And that's the context. Now, I would argue, as I've already argued, that actually 615.2 really only exists for the majority of cases that are issued at the last minute. But in fact, the words critical in 48 is just a reference to how the Court of Appeal had dealt with it by looking at both events before and after issue of claim form. And so I take your Lordship's point. I perceive I'm making a similar point, albeit in a different way. But anyway, I have no doubt at all that my learned friend will be placing great reliance on 48. This appeal is in fact, is de facto an appeal from the decision of Judge Godsmark. That's because it was accepted the district judge was wrong because the district judge didn't take into consideration a bailer. The case was decided on the basis of Mitchell. And so the hearing before Judge Godsmark was a hearing de novo.
No, but it's actually an appeal from the Court of Appeal. You've got to persuade us that the Court of Appeal went wrong, and you're no doubt going to come on to say why. But
well, I will, and I hopefully won't start. But well, I think to understand the decision of the Court of Appeal, I have to take you. I've got an hour left. I have to take you to the decision of Judge Godsmark. Because Judge Godsmark, in my respectful submission, got it obviously and clearly wrong. Because he said, can I take you to page 201, which is paragraph 10 of his judgment. So that's in the first volume. So, paragraph 10. The questions that need to be posed in the light of the authorities of a bailer and power are, in my judgment, two. Firstly, why was it that the claim form could not have been served in the ordinary way during the period of its validity? If a good answer to that question was provided, then the next question becomes, is there a good reason to make the order sought? In other words, an order that service do stand by alternative means, perhaps even retrospectively. The critical consideration in that latter question is whether the claim form and its contents had actually come to the attention of the proposed recipient. Now, with the greatest of respect to the court below in this case, Lord Justice Floyd does not take exception to paragraph 10. He cites paragraph 10, but somehow, in a way that may not be satisfying to your lordships, reasons it away. But with respect, Judge Godsmark says this is a two-stage test. And the first question, before the claimant can get anywhere, is why was it that the claim form could not have been served in the ordinary way during the period of its validity? And so, and it's perfectly clear that the claimant is not going to win on that question. And as I've tried to submit to the court, it's
well, you say that's not a prior issue. It isn't a precondition of the power that the claim form could not have been served earlier. The reason that it wasn't served properly is relevant to the good reason to deem it good service,
yes,
but it's not a precondition that it couldn't have been.
yes. And so
That's what you're saying.
You also presumably say that it's not a precondition for getting to stage 2, that there was a good reason why it couldn't have been.
yes,
Even in a case where it, well, I mean, that will affect one's view about what
Yes.
good means in that context. But you say there isn't a stage 1 good reason test followed by a stage 2 good reason.
well, indeed. So with respect, one thought that Judge Godsmark had got it wrong. Whatever the Court of Appeal might say, it was difficult to think that that the Court of Appeal could say that Judge Godsmark had got it right. Well, and that's set out by Lord Justice Floyd at page 154. So this is page 34. Paragraph 34 is at the bottom of page 154. In the light of those authorities, and then there's the two-stage test. And there's an explanation given. Just before I give it, can I just flag and not take you to the reasons that the two-stage test is wrong? It's a Baylor, paragraphs 33 and 35, and Karki in particular. Lord Justice Aikins, paragraph 28. And Lord Justice Aikins says one good reason.
Where is this? Sorry.
Well.
Or is it quoted here?
It's Karki is tab 11, 852. And so it's paragraph 28. This is the case where the city firm of solicitors hadn't done enough, seemingly negligently, to be able to sue the defendant in Saudi Arabia. So, two initial paragraphs go together, but 5 lines down, one good reason only is sufficient. It's also significant there's no other qualification in the wording. So, then at the bottom, I do not accept if a court has found there's a good reason, and he emphasises the indefinite article, a good reason to authorise service by a method not otherwise permitted by Part 6, then there's a further discretion which could result in the court not doing so. The basic question, as is clear from a Baylor, is whether there's a good reason for the authorisation or not. So I argue a good reason, a simple mistake, no prejudice, no nothing. So it's clear then that before carrying out the evaluation, the judge shouldn't set any hurdle. That seems to be accepted. Now, Lord Justice Floyd's explanation of this is at paragraph 45 and 46, page 169 onwards. It's probably not helped that for some reason we've got two copies of the judgment in the case. So, under the heading discussion, Lord Justice Floyd deals with this. It's fair to say that at 10 of his judgment, the judge appears to pose the question, why was it that the claim form could not have been served, as a threshold question, before asking himself whether there was a good reason to make the order sought. Had he left the matter there would, in my judgment, have been much force in Mr. Elgott's submission that the judge had failed to have regard to all the factors that were relevant and focused too much attention on the paucity of reasons for non-service. But the judge did not leave it there. He pointed out next, correctly, that the critical consideration in deciding whether there was a good reason to validate service was whether or not the claim form and its contents had come to the attention of the proposed recipient. He went on to refer to 33 to 38 of a bailer, pointing out again correctly that the critical consideration was not enough, not of itself enough. He reminded himself in particular of the fact that the purpose of service of proceedings was to bring the proceedings to the attention of the defendant, and that in considering the conduct of the claimant, the relevant focus was on why the claim form could or could not be served within the period of the validity. Well, that's what 45 says. But the question is, does 45 actually sum up what His Honour Judge Godsmark was doing? Because the judicial technique in your Lordship's experience is not necessarily usual, even in an extempore judgment, of posing a threshold question and then mysteriously, somehow, saying thereafter that the matters I'm taking into consideration, which don't seem to be relevant to the threshold question, are being taken into consideration for different reasons. I mean,
so the Court of Appeal was with you about the inappropriateness of that first question.
yes.
And their answer to it is, if, having posed the first question, the county court judge had said, well, I'm afraid the claim form could clearly have been served in the ordinary way, end of story, then that would have been quite wrong. But the Court of Appeal, rightly or wrongly, goes on to say, actually, he didn't treat it as a threshold question. He went on to number 2. Now, was the Court of Appeal permitted to analyse the judgment in that way?
No, in my respectful submission. I have to face it head on. I mean, one has read the judgment of His Honour Judge Godsmark several times, it's fair to say, during the course of applying for permission to the Court of Appeal, during argument, during preparing the case. And it is extremely difficult to read, to read the judgment in that sense. It is true that many of the matters that ought to be taken into consideration when treating the question of good reason are dealt with. But the manner in which they're dealt with seems to suggest that the critical issue for His Honour Judge Godsmark was this issue as to whether the claim form could have been served properly. Well, of course it could have been served properly.
Yes, I mean, I suppose in your favour is the fact that the judge used the word the latter question. He talks about the critical consideration of it come to the attention as being relevant only to the latter question,
Yes.
i.e. the question of good reason, which he distinguishes from the prior question, could it have been served in the right way?
Yes. So at the very least, I can argue before this court that that Lord Justice Floyd gave too much weight to, forgive me, that at the very least, Judge Godsmark, and as I will go on to argue, Lord Justice Floyd gave far too much weight to the question as to whether this could have been served properly.
I've read it less. I've read Judge Godsmark's judgment less frequently than you have. I'm quite sure. But at the moment, one way of looking at it might be this. Tell me what you say about it. He did look at what indeed in our bailiff we're told we ought to look at. That is, one
Yes.
served earlier. He then said, well, the reason was because your client didn't know the rules. That's not a good reason, and that's the end of the case.
That's what he said. In effect.
Well, that's not a good reason for not having served in time, and therefore that's the end of the case.
Yeah. Well, paragraph 14 is focused on that, isn't it? Its judgment.
Milady, paragraph 14 of
Judge Godsmark.
Yeah.
14 and 15. Paragraph 14 reads, it reads to me as if he was asking a threshold question.
Indeed.
Was there a good reason why he couldn't serve
Yes.
properly? And then he answers that question, no.
And so, so primacy was given to this issue by Judge Godsmark. And if primacy was given to this issue by Judge Godsmark, and the Court of Appeal thought Judge Godsmark's judgment was correct, then it is at the very least a lever into my arguing that the judgment of the Court of Appeal was wrong as well. So paragraph 46 of Lord Justice Floyd. Thus, when the judge said that the whole focus of the appeal boiled down to whether there was any reason why Mr. Barton was not able to serve the claim form, he already had in mind the critical question of whether the claim form had come to the attention of the defendant was to be decided in the claimant's favour. What he was looking for was whether there was anything in the other circumstances which could be advanced on the claimant's behalf to allow the conclusion there was a good reason to validate service. He concluded that there was nothing in the way the claimant had conducted himself that could be weighed in his favour. But I mean, nothing. Here was the litigant in person who had got absolutely everything right, apart from this, what he says vehemently was a rather minor error. So the Court of Appeal says there's nothing that could be weighed in this man's favour. And there was no reason why he couldn't have served within the generous time limit allowed. Well, there was a reason. The reason was he made a mistake. But is it a mistake which should lose him the right to a trial? So, in my respectful commission, can I also take you to paragraph 90, page 90. Sorry, I can't read my own writing. Paragraph 97 of my case, which deals with which deals with inferences of fact.
What page is that?
It's page 75, as my junior tells me. And again, can I put before the court that Lord Justice Floyd concludes the judgment by assuming that the respondents' solicitors did appreciate fairly quickly that service was irregular, but they'd need to take their client's instructions before expressly alerting the claimant to the defect in service, thereby exposing their clients to an action which would otherwise be statute barred. Now, my Lord Justice Briggs would perhaps be, again, better served to remember what happened in Power than many, where there was the suggestion of game playing by the solicitors in that case. But the inference drawn by Lord Justice Floyd seems to have been that BLM wouldn't have had time to take instructions from their client and therefore couldn't be criticised for failing to draw the appellant's error to his attention. But and then your lordships will have seen the allegations of bias and so on and so forth that was in the hand-drawn application for permission to appeal here. But can I put it this way? It's just as likely, more likely, that given there's a professional defendant, that the respondents had indeed seen what had happened and actually deliberately failed to draw it to the attention of either of their client and in other words, to decide not to take instructions or, in fact, take instructions. Very easy, with a phone call or indeed an email, to say, can you give me instructions on this? And there is no evidence before the court as to what the defendant solicitors actually did when they read this email. And so to draw attention to this, the claimant's done his best with a homemade witness statement to start this. The defendants choose not to put in any evidence. A more likely assumption is that any evidence they could have given on the point would have been evidence that they had deliberately decided to play games. And it's simply not a necessary or useful inference for Lord Justice Floyd to draw that it was all too late.
I mean, does it affect your case? I mean, you're not making any positive allegation against the other side, are you? That they've deliberately failed to do so?
Well, insofar as Lord Justice Floyd relied on that inference, I would urge the court not to rely on it. The court can draw its own inferences, but it doesn't, with respect, seem to be a necessary inference. It was not canvassed in argument, the particular point.
Can you just help me on one thing puzzled me? In the statement of facts at paragraph 9, which you draw to our attention, it says that the date of receipt, the respondent had everything necessary for good service. Now, does it mean that, or does it mean the respondent solicitors?
Well, yes, I'm using, or we're using respondent as shorthand for respondent solicitors, and we could.
Yes, but I mean, so no distinction is drawn. I mean, at some stage there was questions about whether they had authority.
Yes.
Neither of you have drawn a distinction between the respondents and their solicitors for the purpose of this case.
Indeed, I'm sure that's right.
All right, thank you.
But there was the original issue in a letter of the 4th of July said that not only do we not have authority to accept service by email, we also don't have authority to accept service. Now, that was abandoned by the time the case was heard by the district judge. So the only remaining point was the point that we're dealing with today. Hassall and Natalie. Again, Lord Briggs gave judgment in Natalie. Can I start? So this is whether it's relevant in relation to the exercise of the 615(2) jurisdiction. Whether it's a relevant factor to be weighed in the balance that the claimant is a litigant in person. Now, it has to be said that neither I nor my learned friend had any reason to believe until this point was raised by the court in the case below, that any of the cases relating to relief against sanctions, the 3-9 jurisdiction, would be relevant in a service case. And Hassall and so this did not feature in my learned friend's skeleton. It certainly didn't feature in mine. And indeed, the reason we were in an appeal at all was because the original decision was based on circumstances surrounding 3-9. So relief against sanction. And so this was raised de novo by the Lords Justices in the court below. But my first submission, is seemingly the obvious submission, is that there's no reason why a decision on relief against sanction would be relevant in a service case. Decisions on relief against sanctions don't seem to have appeared in service cases in the past. There's a big difference between a claimant who is within the system applying for relief against sanctions and whose case has already been case managed and who has disobeyed a rule or an order. I mean, classically, even in the smallest cases, a district judge will send out an order expressed in simple-ish language, and if somebody is applying for relief against sanction, then ordinarily one might imagine that they didn't have the whole of the rules of civil procedure to look at. A litigant in person, for instance, would be working from the directions that had been sent out by the district judge. So one can see that there might be every reason, for the reasons set out by my Lord Briggs in Natalie. Once a case has been case managed for my Lord Briggs says in Natalie that there's only that it's likely to only have a marginal reference, but difficult to see why that should apply in a service claim, for all the reasons set out, which I'm not going to have very much time to deal with orally, but for all the reasons set out in my case about the difficulties that litigants in person have. So once somebody's within the system, one understands the position. Now it may be that Lord Briggs will say that he had all matters in mind, but reading the judgment in Natalie, it is focused on relief against sanction.
It might be said against you that the reason why the relief against sanctions jurisprudence might be thought relevant to this question is that both employ the phrase good reason.
Indeed. That's of course true, but good reason in the service jurisdiction came before good reason in the 3-9 jurisdiction, and there's well, unless I'm wrong, there's nothing to suggest that good reason means the same thing in both jurisdictions. I mean, if that were, I mean, for instance, there's no case or ex cathedra pronouncement that I know of that the Denton good reason was supposed to mirror good reason in 615.2. But perhaps my learned friend can help. But it is true and perhaps unfortunate, perhaps not, that it's the same phrase. But there's nothing compelling to say it should be interpreted similarly, particularly seeing as starting a case is different from being a litigant within a case. In any event, Lord Justice Floyd seems to have gone much further than anybody had gone previously, and I deal with that in my case. From 84 onwards, which is on page 71. So the wording used by Lord Justice Floyd in principle, this is Lord Justice Floyd's Principle 6. Says that following Hysage and Natalie, the mere fact that one party is a litigant in person cannot on its own amount to a good reason to validate service. Well, just stopping there. I mean, that's if one stops there, that's obviously true. But then, although it may have some relevance at the margins, that is, with respect, not so self-evidently true. And indeed, it goes further than my Lord Briggs had gone in Hysage. Because in Hysage, Lord Justice Briggs, as he then was, said likely to. And so there was a caveat there. And with respect, likely to means that there are going to be some circumstances where it's where the relevance can be more than marginal. And so, can I take you to? I think for want of time, can I ask you to look at the case where I actually set out various matters? Right, 86. The reasons that this principle should not be. Page 72 if you haven't got it. The reasons that it shouldn't be applicable in claims for validation of service under 615.2 is, firstly, 3.9 doesn't apply. The other case, no other cases cited relating to 3.9 have applied in the past in this. And in particular, the point is emphasised in the research by Lee and Chekakova, which is at 1086, towards the end of the second authorities bundle. So this is tab 29. And so I argue in the case that a litigant in person ought to have a much better understanding of what's expected of him or her after a district judge has made an order than when he or she is attempting to commence the claim. And Professor Lee's research, 1086, suggests that there is a considerable level of satisfaction with what happens in court once the litigant in person has got to the stage of having a hearing. So, unfortunately the paragraphs aren't numbered, but just above halfway there's a paragraph which just below no like I've just got to take myself to court, which is what was ordered in italics. Now the next paragraph, second sentence, it's striking that judges do appear to handle hearings in a manner that's accessible to litigants in person before them. And going to the next non-italicised paragraph, this was backed up by other interview data which broadly showed that litigants in person are happy with and have few problems in understanding judges, but do experience occasional communicative challenges with legal representatives. So it seems that the problem is getting into the system, not once the litigant is in the system itself. That's my A. My B on page 72 is that that CPR 6 and 7 and their practice directions are of greater complexity than most other rules in the CPR. One just has to look at the volume, and we go through that when we look at what would be facing a litigant in person who has actually found their way into the rules of the Supreme Court. They are met with page after page after page after page on service. Not just CPR 6, which goes to 645 or something, but also several practice directions. But that's not the end of it, because you've got to read 7 as well. And the litigant in person has got nobody to point him the way. The rules are framed in technical language unlikely to be fully understood by a litigant in person. don't seem to be fully understood by the judges and lawyers in this case in relation to the various errors that I've pointed out at the start. And the rules fail to indicate the severity of any sanction for non-compliance, such as the loss of the claim. If CPR 6 was headed failure to follow these rules on service may lead to your claim being struck out, then a litigant in person who had got that far would know. But there is nothing within CPR 6 that says that the sanction for serving by email rather than in paper is the complete loss of the claim, or even a possible sanction. And how a litigant in person is expected to know that, then, I mean, let's say, just like the average football player, he knows that there are laws of the game. He's got a working idea of of what the rules are. But he's never going to read the rules of the game and understand them with all the various commentaries that there are in the rules of association football. He's going to do his best. He knows that if he's violent, he'll be sent off, and so on and so forth. And so this is the way, in my submission, litigants in person come to rules in general. They don't read, if they're buying a car, they don't read the small print. If they're entering into serious long-term finance, they don't read the small print. They know their small print in relation to appearing in court. But they don't. But does the litigant in person really think that he or she has to read all the rules in order to take part? Now it's difficult for those who are lawyers to think like that. But can I commend that to the court as being a reason, an additional reason, why the rules relating to service should be treated differently to breaches of the rules once the case has started? And to put it another way, once a case has started, a claimant is not going to be struck out if he or she sends the witness statements electronically when electronic service isn't allowed. Once the case has started, the defendant may take the point, this is not good service, you're out of time, you've got to apply for relief against sanction. What would happen, I venture to suggest, is that the Denton principle of not taking silly points and cooperating with the other side would kick in, and any district judge would say, look, Mr. So-and-so, you've had the witness statements, did you have difficulty in reading them? I'm going to award costs against you, and I'm going to award it on an indemnity basis. So there is something very different about service because of the sanction, which means that you cannot import good reason from stage 2 of Denton into good reason for 615.2. And so even in Hassall, which I know Lord Brigg was not involved, but Hassall, which came a couple of days before Natalie, only said that I do not think that the court can accept the mere fact of being unrepresented provides a good reason for not adhering the rules. And so those words set out page 73 of my case. Well, that was stage 2 of Denton. And so, and with respect to, I think everybody can agree that the mere fact of being unrepresented, I've put it in bold, does not provide a good reason for not adhering to the rules. So, in fact, that takes matters not much further. But obviously what Lord Briggs had to say in Natalie goes further than that. And so the paragraph I cited from Denton, the court will be more ready in the future to penalise opportunism, paragraph 96 of my case. So this is very difficult for a litigant in person. It's opportunism to say, I'm really sorry, I don't accept service by email of your witness statements. But not opportunism to say, I'm really sorry, I don't accept service of your claim form by email. Now, as lawyers, everybody understands where these rules come from. But to say that litigants in person would have the remotest understanding of this, and in my respectful submission, the failure to accept this service as good service by the response is the same opportunism, certainly to the outside world, as the opportunism that Lord Dyson was referring to in Denton. Right, now. Can I go back to the principles elucidated by Lord Justice Floyd? Again, I've set them out for time purposes. Can you take it they've been copied and pasted properly? Paragraph 101. These are the principles.
Sorry, page?
76, I'm sorry. So, the 8 principles for the court to follow have led, as we know, to a plethora of cases which are on this very point, on 615.2. It has not stopped satellite litigation. We've seen what Master MacLeod has said about it. It's like Bluebell time in Kent with these cases about service. Cases in the list of authorities. It's only the rather graphic first paragraph that is worth looking at in this context. There's another one very recent, about the same time as we were compiling the authorities, where they'd argued for 2 days on 615.2, mainly on 615.2. But so we have these principles. Now, principle 1, nobody can disagree with. The court should simply ask that there's good reason to do so. Well, that's not what the Court of Appeal have done in this case. 2 is true. The critical reason, that's from Abella. 3 is true. 4 is true up to a point. Whether there's a good reason, there will be inevitably focus on the reason why the claim form cannot or could not be served. Well, what actually wasn't served would be a better way to phrase it, although I accept there is no judicial sanction for that. But
why? I mean, is that a principle? Or?
Well, it's not.
It doesn't come out. Oh, I see. That's where you get a.
Well, I am. the submission is that principle one is fine.
Yes, I mean that's a question the rules ask.
But all the other principles might lead to too much focus on one or the other, and focusing too much on 4 was the reason that Judge Godsmark got it wrong in my respectful submission. It elevated 4 over principle number 1. Nobody could argue that these are not relevant factors, but there may be other.
The reference there to paragraph 48 of a bailer, I now understand why you refer to that. I must say, I wasn't conscious that I was signing up to a general principle. I mean, that was a statement made by Lord Clark in the context of that case, but well, it does seem a little odd to pick it out and turn it into a principle.
So what I was trying to say, it wasn't even in the part where Lord Clark was dealing with principles. And that's why I was highlighting.
Yes, well, that was why I picked you up on when you were referring to it. I understand now why you did.
Indeed.
Actually, if you look at Lord Justice Floyd's judgment 19, he doesn't describe them as principles.
No,
he says he's summarising the effect of the authorities. So let's not get too involved in what's a principle and what isn't.
Well, what's the difference? I'm not. Unless they're principles, I'm not sure what the point of being set out is.
I mean, they've certainly been used as principles in the subsequent cases. Well, again, some of the subsequent cases can be seen by your lordships. Of the 5, obviously the conduct of the claimant and the defendant are relevant. Well, they must be. And it's true, it's not necessary to show he's taken all the steps he could reasonably have taken. True as well. 6 with respect, is wrong. It's imported something, a principle from a different system. I've already argued at length. The technical games of 7 adds nothing whatsoever to 5. And again, the technical games are taking a technical point which would not get anywhere near success in any other context apart from service. It'd be absolutely hopeless to take a point that you only got served by email once the case had started, and you would get indemnity costs against you. Principle 8 is obviously correct. And 102, I isolate power and actually what happened in power, what happened in khaki. They're all cases where all manner of mistakes were said to be okay by solicitors. This is a case where a modest mistake is said not to be okay by a litigant in person. In relation to reading that I'm going to invite the court to do, given the time constraints, can I in the last 5 minutes or so go back to the case, go back to my case and start with paragraph 26. The reason that I've left this right to the end is not because these matters lack importance. It's page 58. It's not because these matters lack importance. These matters are just as important as any other. However, these are basically factual matters. So there's reference to the difficulties that litigants in person have. We go right back to Lord Wolfe, who was trying to simplify the system for all, including litigants in person, probably succeeded everywhere but service. There's reference to who the appellant was. I've dealt with that. We know what the evidence was. go on to page 61, paragraph 36. There's the concerns of Lord Wolfe, unfamiliar with language and specialist vocabulary, have little knowledge of the procedures involved and find it difficult to apply the rules even if they do read them. Now, it would be wrong in principle to say that litigants in person who we know find it difficult to apply the rules even if they do read them should not be able to have that taken into account. But maybe it probably doesn't affect this claimant, but for the general principle. But all the way through these cases, people talk about the very clear terms of the rules about electronic service. Well, very clear to most lawyers. Certainly not very clear to litigants in person. And Lord Justice Floyd says, well, his view might be different where the rule was difficult to find or ambiguous to a non-lawyer. So we took up Lord Justice Floyd's challenge and pretended that we were litigants in person and to see whether these rules were difficult to find. Expecting, actually, that they wouldn't be difficult to find. But the following pages go through what we did. The court can see that we did it in the way that was assumed would be done in a report called Access to Justice for Litigants in Person, which I think was the forerunner of the handbook. And looking at the court service website or the DirectGov website. But that wasn't good enough, so we did a cross-check against Professor Lee's paper, which only came out in this February. And that's the paper I've referred you to. And we found that it was true that the DirectGov website was the website most used from the sample they took in Birmingham. But only 5 out of 193 respondents used that website. This is paragraph 43 of our case. Indeed, only 50 out of 193 respondents, and this was in a civil justice centre, cited the main source of their information was the internet at all. The list of websites consulted was created, but the authors of the report noted the most useful websites are largely missing from this list. And in particular, we note there's no reference to any litigant in person in this relatively small sample having consulted a handbook for litigant in person, at least in an electronic form, notwithstanding the work that these county court judges must have put in to produce that excellent, in many ways, handbook. And only one respondent out of 193 referred to having consulted the Ministry of Justice website, where the CPR are to be found. So, unfortunately, the assumptions that lay behind the thinking of the various judges in this case are demonstrably incorrect insofar as Professor Lee's research throws any light on this. And so we've put the whole of the paper into the authorities bundle, and it does repay careful reading. And presumably, one of the things that you will see if and when you read this is that the straight question, did you read the CPR? Some of them, I think, were family cases. But did you did you read the rules relating to family cases? That question never seems to have been put by the researchers who seem to work very hard in this. And we pondered on why it was never put. And although one doesn't know, one suspects the reason it was never put was because it was vanishingly unlikely that the answer to the question would have been yes.
Well, Mr. Algott, you have reached your time limit.
Well, yes. Can I just ask you, in the court's own time, insofar as the court will, to look at the internet search we did. It's all set out in...
Well, you've helpfully provided us with it in rather larger print than annexed to your case, for which I, for one, at least, am grateful. But I must ask you now, Mr.
I'm sorry.
Algott, will you please finish your submissions? Your time limit is up. We're very strict on time limits.
I'm obliged. The only other thing that I'm pressed to refer to are the cost submissions that my client has received permission to appeal on. They're set out in full.
Yeah.
Again, in the case, and he expresses it extremely eloquently. I'm grateful.
Thank you very much indeed. Ms. Telford? Well, the court will now adjourn and we will hear from Mr. Pools at 2:00.